If you or your business are facing a breach of contract issue where you have a written agreement and the other side just hasn't abided by the terms of the agreement, ultimately, the terms of the agreement are what's going to govern. Usually, every contract that's well written or well drafted is going to have a clause known as the integration clause. And that clause typically starts with something like where it says entire agreement. And it goes on to say that the written agreement is the entirety of the agreement, that you can't bring in outside text messages or emails or other things to be able to interpret the contract. Now, this is really important because a lot of times people will try to use outside things beyond the contract to try to claim that was the ultimate agreement. So whenever it comes to a breach of contract claim, first and foremost, at the core of it, at the center of it, is going to be the written contract and what the terms are. So you want to make sure that you understand all of the terms and understand all of the timelines and understand how everything's supposed to be done under the agreement. If things aren't being done in compliance with the agreement, you may have specific ways that you have to demand a remedy of the breach. Said differently, the agreement may say exactly what you need to do and how to request the other side perform under the agreement. And if you don't request those things in a timely manner, as laid out in the agreement, then you may be waiving one or more claims, or you may have problems if you just go off and try to sue them or try to file an arbitration claim. So you want to make sure that you've got somebody who helps you through the agreement to make sure you understand it. And most importantly, don't wait. There's a 4-year statute of limitations on the breach of a written agreement, and that doesn't stop or pause just because you're trying to negotiate or work out a resolution. And it also doesn't mean that you should wait a full 4 years before you bring a claim or stand up for your rights. Look, if you've got rights under an agreement, it may feel like a betrayal when the other side doesn't perform, especially when you've done everything you're supposed to be doing. But this is exactly why you should stand up for yourself. This is exactly why you should have somebody helping you through this process who knows it inside and out, who's litigated it, who's tried it in front of judges and juries. You want to make sure you have somebody on your side who's an expert at these things, who knows exactly how to handle these kinds of situations so you don't leave money on the table.